Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. And we always invite all opposing views. Welcome to another edition of FIT TV. When someone files a document in court, notices of motion, orders to show cause, nothing is friendly. It's written in Latin, and there are conditions and preconditions to deal with. Back up. There are conditions and preconditions to deal with. When you ask for help at the courthouse, you have to ask for the clerk, and clerks are rarely helpful. They say get an attorney. Attorneys are often in the game of complicating the measures so that you can't operate within their system. As per famous divorce lawyer Gloria Aldrich, sometimes we just paper the other side until they can't take it anymore. Most divorce lawyers admit the system is flawed. So what are the alternatives to this? Mayhem, you ask. Okay, we have opportunity to talk about alternative dispute resolution systems rather than go through the clip you're about to see in divorce court, which is coming up.
Divorce is far from easy. You have to file papers, complicated papers.
You too can have box after box of really upsetting paperwork to deal with. And that's one of the problems, is that once you get involved in this stuff, there is so much paper and records and inventories and receipts.
These are the binders of information that they sent, and there's nearly 1,400 pages.
Her file was essentially 8 boxes of material.
You're a lawyer, you write a nasty letter, and her lawyer has to write a nasty letter. It's just a great system.
When you go through a divorce and someone files a document in court, you have to respond to it.
We use terms like order to show cause, notice of motion. They're not really user-friendly except for attorneys who are familiar with them.
It takes intense reading. You know, you'd have to read it a number of times.
The preconditions and the blah blah and the motions and the blah blah and how does this affect blah blah.
When you ask for help within the courthouse, well, I'm sorry, you have to go see the court facilitator over there, take a number, and if your number doesn't come up in 8 hours, well, come back again and try over again.
So I called around in a law library in Sacramento. Well, we can't give you that information. Oh, wow. What is this? This is like, top secret priest class stuff.
Essentially paper the other side until they can't take it anymore.
It's just paperwork after paperwork after paperwork after paperwork.
And being overwhelmed with paperwork during a divorce is just the beginning.
To discuss this issue, I have Jeff Bloom, who's a mediator and arbitrator and does dispute resolutions for Nassau County. And he's going to help me with a discussion about some of the alternatives rather than spend all your time in divorce court like the clip just showed you. So what are some of the things we can do, Jeff, besides go to court?
Well, alternative dispute resolution, the short acronym for that is ADR. What I do is mediation and also arbitration, but more mediation, where couples have the option of having their cases mediated. And they have a say in everything that goes into any final agreement and all the final papers they can file with the court rather than somebody telling them what to do.
Yeah, so
which is more important than obviously the money thing, which we can get into in a time.
You're talking about basically the opportunity for a couple to self-determine their future, not somebody else forced on them, not some.
Look, you have a couple who's going through divorce, they have children, they have assets. Who knows what's best for the children, what's best for the assets, than mom and dad? Not than a lawyer, not a judge, they're not going to know what's best.
The system, there's no real incentive to stop them until they run out of money. It's not unusual for us to see people who come to us who try to get help and are stuck in a system that just keeps asking for more money to keep them going inside that system. Why would mediation or alternative dispute resolution systems help in that regard?
Well, absolutely. I mean, you also, Chris, ran into people who told you how much they spent.
Yeah.
And then they get to a point where they're literally out of money. And maybe the attorney put a lien on a house, and so now they're out. Now what do they do? And then they're forced to sign a stipulation of settlement. That doesn't work for either one of them. People don't people don't aren't aware as alternative dispute resolution mediation. They're starting to. It's a little over 40 years old. But again, so you get an attorney. You're going to spend it at a minimum of $15,000 to $25,000 each just for a retainer, and that's not going to be all inclusive, right? So you're looking, that's $50,000 right there. A mediation, soup to nuts, costs less than $60,000. Costs less than $6,000 total.
Right. People are not aware that when you go to court, how much a retainer is, for instance. People throw out numbers like $5,000, $10,000 for retainers. It's not unusual at all.
Well, New York was probably 15, 20. I've seen 5 and 10 occasionally, but that's just a retainer.
Well, rarely. I mean, that's just to get your opportunity to say that you've hired a lawyer to have him help you through the court system. You didn't even get there yet. In mediation, your total costs will be somewhere in that vicinity, or probably less, but it could be more. But
it
that's
could
not
be
a bad
closer
number.
to the 10,000 range if there are experts that have to evaluate pensions and maybe a forensic accountant if there's business or something like that. But again, $10,000, $100,000.
Yeah,
One of the things
but that's
I do,
on the high side, though.
Right. And one of the other things I do, Chris, is I'm an arbitrator for the Nassau Supreme Court, and I'm on a panel that hears attorney-client fee disputes. And most of the cases that I hear are family law cases. And there was one case I worked on recently where the divorce litigation was less than 2 years, and the amount of dispute was $35,000, almost $36,000, just a little over 35.
Right.
And in 2 years' work, and that's one person. So if she spent $36,000, you know, he did spent at least that much, and it's not even over yet. So you're already at $70,000.
To give you a quick example, I mediated for a couple in Nassau County that had been litigating for over 2 years, and their combined legal expenses to that point were $90,000. This is combined, so one was 40, the other was 50 or something. And the lawyers had given up on this saving the problem, so the judge in Nassau County suggested that they use mediators, so I mediated for them. Ironically, and this is a true story, I sat there and introduced myself to them, and she started ranting. She ranted for about 30 minutes straight. I don't know if you've ever heard anybody yell for that long a period of time, but and I didn't know what to do because it was my second mediation. I really hadn't done very many at that time. Obviously, it would only be my second. And she got exhausted. Then all of a sudden she sat down and we settled. And we settled before the 1 hour was up. Here they were, 2 years litigating, $90,000 in. And we got paid $50 for our 1 hour, and that was it. We went home, and they were home. They settled, and the reason is, the court wouldn't allow her to rant. Now, no one knew that. I wish I could say that I knew that. I wasn't being real smart at that time. I really didn't know any different. But truth be told, the opportunity was there for her to rant, and that's what exhausted her. That's what she needed. And when that happened, she was ready to settle. She had to say everything all in one shot.
And that's one of the advantages of mediation, because you get to be heard. If you're in a court setting,
exactly.
The parties don't get to talk to the judge. And there's just a few myths real quick. Sometimes you need litigation, you need attorneys, depending on the situation of divorce. But what you don't want to do is pick that option because one or both spouses, you know what, I'm going to get everything I'm entitled to. Because then it turns into a fight. So let's say that's true. Let's say you think you're entitled to $100,000 with child support and maintenance. Let's say it's the mom, just for example, in a year. Then after everything's all said and done and the litigation is over, what if that's not left? Then what are you going to do?
Right.
So now the one spouse has settled that amount. How long is he going to be able to keep up those payments before you have to bring them back to court, spend for another attorney? Why not save that money and work it out in a room where everybody can speak to each other? And if you can spend all the money in litigation, then what's left is what you're entitled to, not what you were fighting for.
Right.
So you're going to spend, $80,000 for over $10,000?
And people always complain about motions to the court for frivolous reasons, or suddenly the access changes, or while they're in motion, while they're in court, different issues pop up. But in order to pay for each issue that comes, you have to call the attorney and tell him, I want this and I want blank. All right, he's going to charge you for that motion. A motion to do something very simple that would otherwise be handled in a conversation with the mediator. Now you have to get $1,500 a piece for the motion to be heard in court. Everyone wastes their time, and you're spending all that money to ask
money putting the motion together?
to have him come to the door rather than knock on the door or something, or to call in advance, or not to call in advance, something that can be handled in the conversation.
Well, plus you got the phone call to the attorney to suggest the motion. So that he's going to charge you for that. Then he's going to charge you for the research to put together the motion, and then, like you said, to appear in court, whatever they charge. And it's craziness.
No, it's a little wacky. But you're caught in a world where the warning sign isn't really there. Most people that go to court and hire a lawyer to go into court to have their dispute settled have no idea of what's ahead of them. They don't see the warning sign.
They don't. They're angry. It's an emotional thing.
But they wouldn't see it even if they weren't angry because they don't know what to expect. Most people don't have a history. You hear about them, but they don't focus on it because they're not in that place.
Well, but also, Chris, like you know, there are a lot of misconceptions. You know, somebody's angry to go to an attorney, and the attorney's going to tell them what they want to hear, right? Oh, I'll get you that. You're entitled to this. No attorney worth their salt can guarantee an outcome. Every case is different. No two cases are alike. So you get that, and my attorney says I'll get this, I'll get that.
Oh, I've heard that many times.
I've heard that many times too.
Yeah, people don't realize that what you're actually paying for is your anger.
Absolutely.
The more disruptive that the situation is availed will be the more that you spend.
And how many stories have we heard or we know of where attorneys will take a net worth statement and right off the bat they're going to figure out what they're going to bill from that case? And if they got a home and they have the assets, well, it gets to calculate.
We recommend, hopefully we don't recommend you going to court. You come and see a divorce mediator first, but one of the things you can avoid is not filling out an extensive interrogatory.
And there are good attorneys out there, and I know a lot of them who are mediation friendly, who have incentive to settle, who don't want to take all their clients' money and at the end with them have nothing left. But in any profession, you have that kind of thing that goes on.
Well, you get bled to death slowly. If you go to court, it takes a couple of years sometimes to settle the most simplest of issues.
Absolutely.
Luckily, in mediation, you don't need all that many sessions to settle something that you can talk about. It's when you can't talk. By the way, they hire you and they tell you you can't talk. That's a problem.
Right, and that's that communication thing with the litigation.
Right. The acrimony lives in the litigation. It's a place to live. I mean, that's where it advances. That's where litigation is the arena for the fight. And that's not a good way to settle something. Most people know in the back of their heads that if I argue, I'm not going to be totally sensible at that moment I'm arguing. Right. Yet that's what happens.
But when you look at it, the litigation diagram on the screen. You have it where you have the two parties who aren't allowed to communicate with each other. They communicate each with their attorney, and the attorneys communicate with the judge. So you tell your attorney what you want. He bills you for that conversation. He then tells the other attorney, and that's billable. And the other attorney tells his client, and vice versa. It keeps going back and forth. There's no communication between the parties. How are you supposed to get anything done? Yeah. Now you get to court, and there might be issues that are important to you, like you were talking earlier about emotional things, and sometimes you just need their story told. The judge doesn't want to hear from the parties. He won't, or she won't.
Yeah,
they're only allowed to talk to the attorneys.
Well, the paperwork process, the extensive way that the divorce court handles its business is an entire business in itself. And those people who are outside of it, like us as divorce mediators, when we're outside of that system, we don't operate with the same rationale. One of the things that I have as a problem is explaining that to couples that come to see me. Why do I have, do we have this? Do I know my rights? What are my rights? Everybody uses the word rights. They use it so easily. I get these questions all the time. Sometimes they say I need a right to go get a glass of water, but I think it's unfortunate the word right is overused, and certainly it's not necessary.
It's an adversarial term, right? A litigious term.
And it's not necessary in the divorce arena, in a mediative divorce
And I get that
arena.
question a lot, and so do you. So I say to them, listen, I'm a mediator. I'm a neutral third party. I'm here to help both of you. I'm not here to say what your rights are. Only you two know what works best at the end, and that's what we're going to work on. Everything that goes into the final agreement, everything that goes into paperwork is what the both of you want, not what I say that goes in there or somebody else.
Divorce is kind of an unnatural event because the person that you were living with for such a long time and was on your team and was a part of the decisions you had with your children is suddenly not your ally anymore. They become an adversary. Before they become an adversary, I did a program called The Moments Before Divorce once, and I still hold true. It means so much to me. If you capture somebody before they get to court, you have opportunity. Not only do we have opportunity to make the little bit of money that mediators make on this, but we have opportunity to put them in the right place going forward so they don't exhaust all their funds, they don't exhaust the children. The children don't get used as dysfunctional tools, which the court has a way of doing that.
And basically, like we said earlier, the more funds that are left, the more there is to divvy up too.
Right.
You can't divvy up what's not there.
It's a crazy system. And I always say to people too also, why would you want to give up your power? When you, like you said in that diagram before, that you're hiring somebody to communicate for you, you're giving up your power, your ability to communicate effectively. You're stopping yourself from doing what you know is inherent, it's necessary for you to communicate your problem. If you have a problem, talk about it.
But you've seen in court where that's not relevant, that's not important, but it's important to you, right?
Right.
You remember, I don't know if you remember, you just reminded me, when we were in school, remember the telephone game where they would start at one end of the classroom, you whisper something in somebody's ear from a piece of paper, and by the time we got to the other end, it was totally different.
Yes, absolutely.
I'm sure things similar like that happen. You can't convey emotion to a judge from a third party. You can't do it.
This is what my moniker on my mediation page is: divorce is about relationships, and relationships can't be adjudicated. And that's basically what fundamentally is our problem as a nation. We run to adjudicating something before we run to communicate about it. If it's a relationship, that's what needs to be focused on. It's not litigative. It's not litigative friendly. Your relationship is never going to fit well in that environment, and you pay for it. And when you pay dearly. Sometimes you pay for the rest of your lives. We know people who have mortgaged their property and sold their houses and divvied up
depleted their
hundreds of thousands,
funds.
Spent all that money on the legal fees and retainers, depleted their children's funds.
It's scary. It's very scary.
And the reality is you're left with an angry self. And you never make yourself happy when you've done that. So stay out of anger, stay out of court. Those are the two
I always like to define mediation, at least my goal is, and yours is also, that it's a win-win for both parties.
Right.
Litigation is a win-lose or a lose-lose. And the only one who wins in a litigation is
the lawyers.
The lawyers.
Or maybe the judge gets it. No, he gets paid for it. They don't have patience to wait for the peace. The system doesn't have patience to wait for the peace. But in mediation, we have patience to wait for peace. Absolutely. And in peace is where you find your solutions.
Very true.
It's too bad that we can't get everyone to be on board with that early on. Like I said, the moments before divorce mean a lot. There's also a lot of time savings. There's also a lot of ability to maneuver appointments better. You don't have to waste your time or your money. You can create your own time schedule. You can do it at your leisure. You can do it in the evenings.
And that's
you
where
don't have
most
to take
of our
off from
mediations take
work.
place, right?
Right, and you don't have to take time off from work, so you can be more productive in your life, and your family will be more at peace too, because you won't be wasting your money and getting angry about that either.
I meet couples in the evening. I meet them on Saturday sometimes. If I have to do a Sunday, I'll do that.
Sure.
But everything's to the convenience of the couple because they're the ones that are going through this. You go to an attorney, and again, you're paying, tens of thousands of dollars. You got to be there, 9 to 5, and if it's court, it's got to be during the day, and you lose time from work, and that's even more money. It's not a good system.
I always say to people that divorcing in court is like putting a square peg in a round hole. You really can't do that. You have two issues that are theoretically similar sizes, but they'll never fit in. In mediation, it's your family that's fitting into an environment that works where the round peg would fit into the round hole. It's not rocket science.
Right.
It's something that should be very contemplative and very easy for you to handle. So what else is it about your experiences as maybe as an arbitrator, if you can make the connection between mediation and arbitration, just let the audience know what that's about.
The difference between the two is mediation is optional, and during a mediation, the couple's free to stop at any point, and then they can go to get attorneys or just stop the mediation process. Mm-hmm. Arbitration is a binding decision. So as an arbitrator, whether I'm acting as an arbitrator
it's like a
for
judge,
a divorce,
in other words,
right,
more or less, you're making
or
a decision.
on a panel.
It's a panel too could be making a decision. It's
a
collective decision you make?
Right. They agree that whatever the decision of the panel is binding. Now, I've done meet-arb agreements in the arbitration setting, in the mediation setting. Let's say there are 15 issues that the couple come in with, and we're mediating, and somewhere down the line there's 3 left they just can't decide. But they don't want to break up the mediation, they're so close. So they say, okay, Jeff, we will allow you to act as an arbitrator, and now I take off my mediator hat, put on my arbitration hat, and allow them to present their cases for those 1, 2, or 3 issues, and then I'll make a decision out of their presence, and when they come back, I'll let them know what my decision is. Mm. So it's a way of, again, for those 2 or 3 or 1 issue, it happens very rarely, but I offer that as an option. If I see it I don't offer that in the beginning, they don't know about it, but as we get there, if it looks like it's going to break down, and they say, it's 1 issue, Jeff, what do? We can't agree. I'll present that as an idea, and I'll get them through the process.
One of the things that is adjacent or lines itself up with the mediation arbitration process is the collaborative law process. Now, in general, you have to hire somebody. You're hiring several people, including the attorney that you hire.
Correct. You're hiring attorneys, you're hiring a mediator, experts.
You know, a mathematical, accounting, forensic, or whatever they might need,
right.
something like that. And you're doing that to more or less supplement or to have available to you at the time that you're actually meeting to create the decisions that you need. One of the problems I have, I always call collaborative law just rearranging the chairs on the Titanic, because you're still spending way more money than you have to.
You're spending money for everybody who's in a room. The benefit to the parties are the attorneys who are in the collaborative mode have to sign an agreement to agree that if this is were to break down, they can't
represent the party.
They can't represent the parties later and use the information from the collaborative process.
Yeah, I'm aware of that. And
so that's somewhat of an advantage.
That's somewhat of a disadvantage too for the client, because the client may want to have that attorney who they called in to be part of the collaborative process,
but they can't,
to extend out to litigate, and that can't happen.
But the benefit is, again, if you have an attorney who's maybe not on the up and up, and they know, and if that wasn't a restriction, then the collaborative process wouldn't work, right? Because they're not making their money in the collaborative versus the litigation portion.
Well, you know, it's certainly less expensive than the litigation ordinarily.
Absolutely.
Because you're not in an adversarial, not as such an adversarial position. I don't call the collaborative. That's the one good thing about the collaborative process. It doesn't have an adversarial base.
Generally not, yes.
Yeah,
that's true.
Yeah, it's usually one you can communicate with effectively, at least in that same process. Look, we have a couple of minutes left. Just give me some ideas that you may have that mediation might help someone who's coming to need help with their marriage and they're thinking about divorce.
You're going through divorce, or you think you want to, or you both want to, whatever the case may be. This is an opinion where Chris and I differ a little bit. Chris doesn't think they should go to an attorney, but if somebody asks me, I'll say, talk to an attorney, talk to 2 attorneys, talk to 2 or 3 mediators, find out, get educated, so you know what it is you're getting yourself into, rather than 10, 15, 20 years down the line saying, oh, what if I did this? You had mentioned to me and shared that your fear is that if they talk to an attorney, they'll never talk to a mediator.
Well, it's happened to me.
Okay.
More than once. It's happened a lot, way too often. And I think that's because they are able to put the fear of God in them.
And I guess that could happen.
It has happened. You know, I've been doing this for a longer period of time, but...
And you've been doing it longer than I have.
Yeah, so the point is that I would say I lose probably 1 out of every 6, maybe 5 or 6 or 7, strictly for that reason alone, because the fear of God has been placed into about what potentially they could have or not have, or be hurt by or not hurt by, with the threading, well, you could do this, and they're already adversarial protecting their client, and they set the stage for, I wouldn't take that risk, and they put the fear of God in them.
And what's also important to...
I would rather not have that scenario happen. The reason why I'm against the attorney part of it is an attorney lawyer who's going to adversarially, zealously protect their client. That's what I want to avoid.
And another thing, just let the parties know, they could already been started in the litigation process, looking at all this money that's being spent, and not know they could stop that and go to mediation.
Right.
They could tell their attorneys,
important point. Right.
Let's stop. We're going to mediation. I'm not spending any more money, and they can actually leave the litigation process. They could try mediation, and if for whatever reason it doesn't work, they can go back to litigation, or they could start at mediation. If it doesn't work, they can go to litigation. So it's the smartest way to do it.
Yeah, the mediation process, I like to say that the mediation process is good at either end, either in the beginning, middle, or the end. It really doesn't matter, because if you're in the beginning of it, you've saved a lot of money.
Absolutely.
And you've coordinated your whole life. If you're in the middle, you've suffered a little bit, so it makes it easier for us to work, because we already see the pain and the loss of funds and the loss of time you had to go through. And if you're at the end, it means you have one issue that couldn't be settled in court because you were adversarially protected and you could communicate that issue, whereas in the mediation process you can communicate that issue and we can find a resolution. So it's a win-win, and then add another win to that.
I agree.
Right? That works pretty well. And everyone knows who watches this program that I'm a proponent and strongly supportive of the mediation process to resolve disputes. So please help our organization by visiting the website below. You're going to see a website indicator before the end of the program on our credits, so that we can provide mediation services to those who would not ordinarily be able to afford the advantages of mediation. So thank you very much for that. Jeff, thanks very much for your effort here today, and And let's have some more good luck in our business world, huh?
Thank you.
You've been watching FIT TV, the program that brings you behind the scenes of our divorce culture. And at FIT, we know you cannot get this information on your own, so we'll bring it to your TV every week. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.